What's up, everybody? We are back in court for more things happening in the Sarah Boone case. I feel like so much talk has been done about her lawyers and all of them and the new ones and her representing herself. Well, today it's the end of the road for three of those lawyers who asked for the full $15,000 fee for having to work for and with Sarah Boone. Today, the judge makes the decision. JAC will make their arguments, and we will see how much each one of these lawyers got paid for the work they did for and with Sarah Boone. And at the end of the video, we're going to read the latest document filed by the state for the newest witness that they've added against Sarah Boone. And you may think, how is that fair? How is that possible? There's a very good reason for it. And this witness has very good information that will be helpful for the state's case and for the new revelation of what the defense is going to argue. So stick with us till the end. Make sure you guys hit the like button. Make sure you're subscribed to our page. And let's jump into this fees hearing. So Judge Munyon here is just here to make the decision for these three lawyers, Hobson, Bankowitz, and Cashman, who have all asked for the full $15,000 flat fee, which is supposed to be for the totality of her representation for Sarah Boone. And the JAC made the argument that they should split the $15,000 some way, either evenly or based on a pro rata share of how much work was done on the file by each individual lawyer. They were usually okay with the costs. And the lawyers have all shown up either in person or virtually to make their arguments to the court. The audio is a little sketchy from time to time, but we can make out most of what they say. We're going to listen to it on normal speed just because the audio is not great. Break down their arguments. They make a lot of revelations about what it's like to work with Sarah Boone, why they believe this case to be extraordinary, why they believe they're all entitled to $15,000 each, which would be $45,000 for court-appointed lawyers, some of whom worked less than a year on this case. So let's take a listen now to what the judge has to say, to the attorney arguments, and to JAC's response.
Not get a similar statement with regard to Mr. Bankowitz or Mr. Hobson, so I thought I needed to have a hearing with all three of you present. I am, Mr. Lake?
I was just saying, there is an objection here because essentially what we're at this point is
just so you know, the audio gets better. He said there is an objection as to where we're at. This is from the JAC saying we don't want to pay that full amount. And it's not like his money. He's saying he doesn't think it's the right thing to do with the state's money.
This is compensation and he sets the flat fee because there's three attorneys involved. So there's no line item objections per se because these are all flat fee bills. But we're basically objecting on the basis that the total compensation here is going to exceed the flat fee to some extent.
Right. And I will tell you that I am very familiar with Ms. Boone's case because she has gone through many attorneys and has, according to Judge Kranick's order, sabotaged those relationships. And accordingly.
So the judge wastes no time in taking a shot at Sarah Boone that she is the reason for the deterioration of these relationships and she sabotaged these attorney-client relationships. Very interesting. Bodie, why different judge? Different jurisdictions do things differently. And if this judge is available to handle this, sometimes there's like an administrative judge that rotates and they handle all things like this. She was handling a bunch of attorneys' fees and issues on multiple cases today.
Attorneys needed to withdraw and new attorneys were appointed. And I do recognize that a lot of work was done for Ms. Boone. So we will start with Mr. Bankowitz, then move to Mr. Hobson, and then to Ms. Cashman.
Thank you, Ron. Basically, I had the case for a little over a year. I had 175 hours in the case, including.
So this is Mr. Bankowitz. We know about him. He was one of the earlier on attorneys. He says he spent 175 hours when he worked on the case for over a year. I think Cashman said 180 hours in the 5 months or something that she had the case. So to compare that, but he's going to explain what it was like. Each of them are going to explain from their perspective what it was like for Sarah Boone. And it's very clear to me, they are kind of all on the same team here. They're like, yeah, I get what he went through. I get what she went through, especially Hobson relates with the other two lawyers in this case.
actual 45 hours at the jail with the defendant. When I received the case, I got a box of crazy information, I'll put it that way. And it was an entire file box, and it took weeks to go through it, categorize it, and kind of figure out what was going on in the case at that point in time. She originally had a privately retained attorney, and I basically received his case and his file because all of the other court-appointed attorneys before me, I believe, had waived any attorney's fees, and because they did basically nothing on the case. The three of us did a lot of work in the case. As I said, I did 175 hours, and even at the $75 an hour compensation, we're looking at $14,000. Spent a lot of time with Ms. Boone and a lot of time on the case. So I'm requesting a flat fee in this case.
All right, thank you. Mr. Hobson.
Good morning, Your Honor. Good morning, everyone. Your Honor, I got the case from Mr. Bankowitz, and I got the same information. The information Mr. Bankowitz just recited that he had and reviewed, and in addition, of course, his information on top of all of that. I spent some time with the defendant at the jail. I spent a tremendous amount of time with the investigator reviewing the case, talking about discovery, experts, and so forth. I spent a tremendous amount.
Interestingly enough, actually, I feel like Bankowitz took the fewest shots at Sarah Boone, but he's just there to get his money. He's like, I worked on this case the longest. Frankly, he's in the best position to get paid because of how long he was on the case, how many hearings he went to, how much time he spent with her in the jail, et cetera, et cetera.
Amount of time with a proposed expert, Dr. Linda DeRay. That it turns out the defendant didn't like her. I thought she'd be great. We talked for dozens of hours, almost daily, extensive periods of time, coming up with theory of defense or theory.
He spent an extensive amount of time coming up with a theory of the defense. Isn't that interesting? He also said he met with multiple experts, and he's going to say something I actually think is good for Sarah Boone's new lawyers. He's going to mention it here.
Theories of defense. At the in fact, you combine the information from the expert, the force attorney that was privately involved, and took the case to the right up to the edge for trial, and then had to back out. So I had that information. Those boxes are box of information Mr. Bankowitz talked about. I had those. I had to go through those. I gave all that material to Ms. Cashman, plus my information on top of that. Spent a lot of time interviewing people about how they'd respond if they were jurors. So I was looking at the case from all angles. I had the case from, I believe, September 23 until May 24. I would say conservatively, any lawyer that had this case can tell you easily they spend at least an hour to 2 hours on this case every single day.
He said from September to May, so it's at like 8 months, he was taking an hour to 2 hours on this case every single day. That's what he said. Somebody asked, wasn't Bankowitz the one who she said phone never worked? Yeah. His is the most interesting to me because he was on the case for the longest amount of time, kind of, I think, submitted the least hours and didn't push back on some of her complaints. Hobson and Cashman, to me, hit the ground running, dug in, got a lot of work done, battered spouse syndrome, doing a bunch of stuff right away. Shirley said, who is paying for these lawyers? We are, meaning Florida taxpayers is paying for these lawyers. Michelle, how much would you estimate Sarah Boone's new team of lawyers will spend / will cost her given the amount the court appointeds are awarded? So I don't think she's going to end up paying them anything, But it wouldn't surprise me, especially because now she's got 2 lawyers. You're going to hear from Hobson. He thought that was necessary. If this, if they jumped on the case, tried it, within a month or two, $50,000 to $100,000 is probably what it would cost this team of lawyers. I would guess if they were going to have the case for multiple years on a second degree case like this, it's multiple 6 figures is how much it would usually cost, I would think, for private lawyers to come on and handle this case. Rebecca said, Peter, who's going to pay for these lawyers? You can't get blood out of a turnip. So isn't this a moot point? So no, that's the scary part, Rebecca. What's happening here is the judge is going to determine how much the taxpayers are going to pay her. JAC is like trying to save the taxpayer money, saying we allocate 15 grand for this kind of a case. That's what they should get. And instead, the court's going to say whether they get 15 grand, have to split it, whether each one of them gets 15 grand, whether each one of them gets a little less than 15 grand. That's what we're here for. And the judge is going to determine how much the taxpayers are going to pay for these lawyers for Sarah Boone, who did not even finish her case to completion.
Given the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law versus our theory on it was a constant battle going back and forth, and you had to deal with.
So I'm going to back it up because he says it was so difficult, an hour or two every day going back and forth on Sarah Boone's theories of what the law is, what arguments we're going to make, and we battle with Sarah Boone. That's literally what he's saying on the record here.
Every single day. Given the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law versus our theory on it was a constant battle going back and forth. You had to deal with the gaslighting.
You had to deal with the gaslighting, he said. You had to deal with Sarah Boone gaslighting you. It's all on the record. I mean, I probably wouldn't have been so descriptive if I was him.
And I told Judge Kranick at the time that I withdrew that it just was too much. This case required at least 2 lawyers. I told that to Judge Kranick, plus possibly an assistant. I see now the case has 3 lawyers, plus experts that we worked at getting, plus investigators. So everything they're doing now, we attempted to do. We made
So that was an important point. I'm going to pause it on and talk about, because a lot of people were talking about, even the state in a prior argument was saying, Judge, all these other lawyers, none of them did battered spouse. None of them did this. None of them did that. But here's Hobson, who was 2 lawyers ago, saying, we were trying to do all this. We just didn't have the capacity and the time. This case needed multiple lawyers, assistants, investigators, experts, and we were basically doing everything they are doing now, because now they have multiple lawyers, investigator, assistant, battered spouse defense with experts. So even if it's in the undertones, right, because we're dug in so deep on this case and we know so much about this case, we can pick up on this stuff, but he is basically giving credence to a lot of what the defense is doing now. So the prosecutor can point the finger and say all this stuff all they want, but it seems like at least one of the prior attorneys was going to do very similar things that the current defense team is doing. Rebecca said, don't public defenders get a salary? Yes, and it would have been great if Sarah Boone could have dealt with a public defender on this case, but for some reason, they conflicted out and she had to get court-appointed private lawyers. And there's a list that you can be on if you want to as a private criminal defense attorney. And if you are on that list, you go through a rotation. And if the public defenders can't handle it, they pull your name out of a hat, basically, and they say, Ms. Cashman, now you're going to represent Ms. Boone. And if by doing that, you are agreeing, if I get picked for a second-degree case like this, I will take $15,000 as my fee. You're agreeing to that. So if they would have gone all the way through hundreds of hours, tried the case, finished the case, whatever the verdict is, they would have gotten $15,000. Now, obviously, they didn't complete the case, and all 3 of them had to work a lot on it. So what do you pay them?
every effort to do all those things. Ms. Boone now has custody of files belonging to myself, Ms. Cashman, and Mr. Binkowitz. We did just put in a tremendous amount of work. It taxed every fiber in your body and the bodies of the assistants or any person that worked with you on this
It
matter.
was taxing on every part, every fiber of your body, and even the assistants that were working on it. Bodie said, Peter, what about attorney-client privilege? Is that only when there's a current relationship? No. That attorney-client privilege lives forever. It is the client's privilege. You cannot reveal privileged information at a hearing like this. Is this privileged? I would say no, but he's trying to explain how he felt. He's not necessarily saying, what she said. Is it getting close to the line? Yes, I probably would not have done that. I would not have revealed so much information myself.
And I think flat fee for each of the attorney would be exceedingly reasonable, Judge. And I heard the judge comments regarding $75 an hour. I won't even speak to that. It would be totally redundant given the expert knowledge of all the attorneys and Your Honor involved in this case and any other case we come to the court on regarding fees. But this was a extremely difficult case, Judge. Most of the difficulty revolved around just handling the defendant and coordinating the defendant's thoughts on how things should go with what our experts were telling us and our investigators were telling us. So I believe the flat fee for each attorney would be anything less than a flat fee would be totally confiscatory, Judge. Thank you so much.
Thank you. Ms.
And he also said he thinks $15,000 for each is fair. That's what he's pushing for.
Your Honor, I'm asking for the
And now it's Miss Cashman.
So much.
Thank you. Ms. Cashman.
Your Honor, I'm asking for the $15,000 flat fee, and I'm also asking to be reimbursed for the $1,800 that I paid to an expert, and JAC has a copy of my check front and back on this case. One of the issues that always has to be addressed when there are multiple attorneys, and I was the 8th attorney and the 4th private court-appointed attorney, is making.
I will say Cashman's argument is probably most similar to the one I would have made if I was in any of these three lawyers' positions, if I was comparing what all of them did. She also worked the least amount of months on the case, not the least amount of hours, but she's kind of proving her hours, what she did, how much time she took. The way that she did it, I liked the best personally.
Making a case that is old by purposes, for reasons of being on the docket for a long time, a priority, and putting aside other work. One of the unusual things about Ms. Boone's case was when I did withdraw for ethical reasons, the court found that she had forfeited her right to an attorney. She is charged by information with second-degree murder. There was an unusual amount of media attention on this case. The facts are she's accused of putting her boyfriend in a suitcase. He later dies. There is a video of this that went viral. Because the video went viral, because of coverage by Court TV, News Nation, Fox, the local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to review not just the banker boxes of discovery and work done by the previous attorneys, but stay up to date with what potential jurors were viewing if they were watching it on the internet. There was a lot of correspondence between the defendant and the court. Obviously, I had to review all that. The most recent piece of correspondence.
All right, so let's talk about this for a second. Chris said, I know I joked with you about Know Your Lawyer misstatement from before, but serious question, would you prefer that the show was not mentioned in open court? If it is mentioned, do you prefer it is by an incorrect name? I literally don't care at all if they get my name right or wrong, but I do think it's a good question on, do I care if they mention it in court in these kinds of cases? And this should be kind of how I think everybody should think about everything they do. Every text message they send, every email they send, everything they say in a phone call, how they treat people, what you say on YouTube, that if this were to come before a judge, that I'd be okay with it. I'd be okay with the judge watching. If the judge had questions for me, be like, why'd you say this? Why'd you say that? I'd say, Judge, let's talk about it. Because the point and the reason I do this is so people understand what their rights are. They may find themselves in Sarah Boone's situation. They may find themselves in Brian Boone's situation where somebody on this side of their life is going through this. They may find themselves needing a lawyer and not understanding how they get paid. They may find themselves in front of a judge and not understanding how a judge is talking to them. They may be representing themselves. And if they can learn something from this, I consider it a public service that people are understanding their rights and their court system better. That's the point. I think that's important. And I think every judge would agree with that. It's also why I don't try to be overly disparaging to everybody, to anybody, I should say. Try to have grace. I try to call out when I think something's wrong and when I think something needs to be fixed. And I would like to think I can back up every time I have somebody called somebody out. Every time I have had an issue with what a lawyer or a judge has done. And I stand behind everything I've said. So no, it doesn't bother me at all if it's said in open court, if a judge goes and listens, if a lawyer listens and watch. What I actually, one of the things I think in my head and is my filter is if I was Cashman or if I was the prosecutor, what would I want a lawyer to be saying about this case? I would want them to be saying, be fair, be unbiased. Look at the credibility of a witness. The defendant should be cloaked in the presumption of innocence. Those are the types of things all lawyers should want everyone in the public to know and do. What would I not want them to do? Telling you this person's guilty. If you're on the jury, you better convict them. If you're not, you're a fool. That's what I would not want a lawyer to say. That's why I don't say it. It's wrong, first off, but it could poison jury pools. It could have a negative effect. I honestly, truly believe and try to have a positive effect on the court system and the jury system in America with everything I say on here. When people email me and say, I'm so excited to be a juror after watching and following your channel for years because I want to go in fair and unbiased. And if I can't be, I'm going to tell them. That's great. I wish every one of my potential jurors when I'm going to try a case would do that. So honestly, that's how I believe. That's how I feel. That's how I try to act. And so I don't care if they say this to a judge and a judge goes and looks up like, what kind of lawyer is doing this stuff on YouTube? I hope they watch more than 5 seconds and see, oh, okay, maybe this will actually help. Rebecca said, this is setting a bad precedent. Others are going to pull this. Who stops the bleeding? So this can go on in perpetuity. So I will tell you, other lawyers have tried this. Sometimes they get it. Sometimes they don't. It usually has to be extraordinary and unusual, like incredibly hard. For example, like the Delphi case. Let's give that as an example. If that was in Florida and they did all the work those lawyers did, hours and hours and hours, putting together this whole huge thing, coming up with this argument, doing all this stuff, that is extraordinary and unusual. Let's listen to the rest of Cashman before I'll give you my opinion on whether this case fits into extraordinary and unusual.
Respondents, when I was Ms. Boone's counsel, was the 58-page letter that she wrote. And again, all these letters are published, they're analyzed. I, like previous counsel, spent an inordinate amount of time with Ms. Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be confiscatory to not pay me the flat fee. And having provided the requested proof based on the procedure for reimbursable costs, it's my understanding that Mr. Lake is not objecting to me being reimbursed for the $1,800 that I spent to retain an expert who did not have a contract with JAC.
Thank you.
All right. That's her argument. I think it's a good one. Thanks a lot, John. Thanks a lot. Thank you, Fletcher boy, for this is what I aspire to, right? I know John was just kidding with me, which I accept, of course. K-Wag says, as a Florida taxpayer, I'm okay with this anomaly. Hopefully Boone is a once in a lifetime, but these attorneys earned every penny each. Pay them. So here's what I'll say. And this is always a hard balance for me, okay? So I absolutely do not think this case is extraordinary and unusually hard for a lawyer. Is it extraordinary? Is it unusual? Is it a strange set of facts and circumstances? Absolutely. Is it overly difficult for a lawyer to handle? I really don't think so. Think about YSL. Think about Delphi. Think about Karen Reed even. Think about Murdaugh. all the different things and moving parts and the federal charges and state charges and these crimes and other bad acts and all this stuff in all those cases that make them so much more difficult. This case is like 2 banker boxes, a couple videos, cell phone data, and a bunch of YouTube videos to see what jurors are watching. Sure, that makes it that raises the bar a little bit. I think the media attention for sure raises the bar. I just don't think this case is overly extraordinary and unreasonable. So then, do I think they should all split $15,000? I don't know, right? If I was the judge, I probably would give them more than the $15,000 total. Would I give them $15,000 each? I think my answer would be no. I would not give them $15,000 each, but I would not give them $15,000 total. It would be somewhere in the middle, maybe 10 grand each, something like that. Because I do believe they all worked. I believe they all worked hard, especially Hobson and Cashman. And I think they did earn their value. And I think the JAC number for hourly work is like $75 an hour. So in saying that, I am not saying that a lawyer's worth is only $75 an hour, $10,000 or $15,000. Okay. So like, for example, I would never handle this case for $15,000. I'm going to be honest with you. Okay. I know some people won't like that. It may sound braggadocious. I'm not trying to make it like that. I'm trying to explain a point. I would not want to. I wouldn't. Not just this case. Let me be more clear. I wouldn't handle any second-degree murder case for $15,000. I don't care how easy or hard it is. It's very serious. It's going to take a lot of work, stress, and time. But that's why I'm not on the court-appointed list. So I think if you choose to, it is a free choice to get on the court-appointed list. And Paverhart asked if they went to regional counsel before. I don't think so. I think they just went to court-appointed counsel after public defender conflicted off. So if you decide to go on the court-appointed list as a private lawyer, you know what you're signing up for. Same thing as me. Have we underquoted fees before? Absolutely. Have we quoted X amount of dollars and at the end of the case, we were like, holy crap, that was not worth it. We worked way more than that, but we still do the work. We still finish the job. We have a contract. We have a deal. We made a decision and we finish it. And there have been cases that have been easier than we thought they were going to be. Right? In a flat fee, you don't give the money back. Because the totality of the work, the result, the outcome, the time, the leverage, the energy, the negotiations, whatever it may be, that's the agreement. And so from my perspective, that's the only reason why I would probably come somewhere in between. Frankly, I'd give all these lawyers, if it was unlimited money, I'd give them more than $15,000 each for the work they did on this case. Because I think the value of their work is considerably higher than $15,000 each. Considerably higher. For 180 hours here, 45 hours with her, meeting with experts, investigators, taking all this time. So don't get it twisted with where I'm putting the value on their work. Absolutely not. I'm just thinking when you go on this list and you undertake these cases, Rebecca asked, can they refuse the case? In certain circumstances, yes. However, if you refuse all these cases, you will be removed from the court-appointed list eventually. And I believe, so I've never been on a court-appointed list. Lawyers in our firm have done it in federal court. I believe you can put on there, or you might have to sign something saying, I'm willing to take all these cases or all these kinds of cases, different things like that. Good news, after breaking my hip, I have now been released from PT, still using a cane, but doing good. Jacqueline, heard that's brutal. So I'm glad you're on the mend because that's tough. That's tough. Amanda, my favorite thing about this channel and chat, aside from the grace and dedication to fairness, is that you make arguments from the perspective I hadn't thought about. Love that. Thank you, Amanda. And a lot of it comes from responding to questions. So that's what makes this channel, is the engagement and interaction with the chat. All right, so let's hear the judge's decision. Is she going to agree with me? Is she going to do something in between? Is she going to give them each 15? Is she going to give them less than 15? Let's hear her decision.
Thank you, Mr. Lake.
By the way, sorry, first we're going to hear from JAC and their objection. Also, listen to how the judge again talks about Ms. Boone.
Yes, Your Honor, just briefly. But as far as the issue of the $1,800, JT has no objection to that reimbursement. That's more of a technicality. The court did approve the expert. This is just the attorney getting reimbursed for expense that we have no objection to. So that's a non-issue. But you see that in the order. As far as the fees are concerned, the issue here is that other than Ms. Cashman, who submitted an hourly statement of 118 hours, none of the other attorneys actually submitted hourly statements, so we are kind of constrained by the
He's saying Cashman submitted the hourly breakdown, the other lawyers didn't. So that kind of ties our hands, makes it more difficult procedurally. We'll see if the judge cares about that.
statute. The problem is the statute only allows up to 200% of the flat fee in the absence of hourly statements. In other words,
So he's like, you can only do a flat fee if you don't have those hourly statements. So really the only way to be able to grant it is flat fee 15 for Banquets, flat fee 15 for Hobson, and then hourly 15 for Cashman.
if the statute word very unusually, but essentially what it says is the court can award up to 200% of the flat fee without, and then it can only go above that if it finds that the case is confiscatory, and then can compensate the attorneys at a rate of $75 an hour. So that's where we get into a little bit of a difficulty here, because double the flat fee here would be $30,000, which is less
So Jocelyn, this courtroom is particularly bad when anybody is appearing virtually.
than each of the attorneys. If he's requesting 15,000 each, it would be 45,000. As far as, and at that point, looking at the statute, what we have is Ms. Cashman, she got 118 hours in. That would represent at a rate of $75 an hour, $8,850. Based on Mr. Bankowitz's statement, he has 175 hours in, which would be $13,125 at that rate. And Mr. Hobson, he just basically said about 200 hours, which would be 15,000. That's the issue, Your Honor, is that, I mean, technically compensation has to be at a rate of $75 an hour for it to go above 30,000. And so beyond that, I mean, ultimately, but you leave it to court discretion to determine reasonable fee for each attorney, and we acknowledge that this. I don't think we can even begin to dispute that this is not an extraordinary unusual case. It's just that what the statute says is.
Even he's like, I'm not going to say it's not an extraordinary case. It's like, it is an extraordinary case, but what they mean is not a wild case. Is it an extraordinary and unusually hard or difficult one for the attorneys? And that's the only spot I would kind of disagree with what they're saying. It's just me personally.
How the compensation structure is set up, and we have to argue that the court needs to follow that structure.
Mr. Lake, if one bills hourly, can the others be flat fee under your interpretation of the statute?
You can always see where a judge is leaning based on their questions.
That before you get to double the flat fee, yes, at work, but once you go above double the flat fee, then at that point, it really should be compensation, should be 75 an hour. However, we also acknowledge that we have had other cases like this where the court has awarded the full flat fee to each attorney, and we've never taken it up.
JC figuring it out, doesn't really want to fight with the judge. He's like, we have had other cases, Judge, where they've just given everybody 15 each.
I mean, it's essentially, we have to argue that you can only go to 200% of the flat fee, and at that point, it has to go hourly. But we also acknowledge that realistically, there is no attorney on the case, other than somebody who might take the case pro bono for other reasons. There's no attorney on the surface of this planet that would take this case for 15,000.
Your Honor, if I may address.
I don't
The
need
court.
I don't need to do
She's like, just be quiet. You've already won. You don't need to say anything else. You've already won.
that, Mr. Hobson. Thank you.
Yes.
I am going to award the $15,000 flat fee to Mr. Bankwitz and Ms. Cashman, and a $15,000 hourly fee to Mr. Hobson. Ms. Cashman will be reimbursed her $1,800 in costs. I will issue an order to that if on each of these cases. You've sent me orders electronically, and I will e-sign them. I've got it here, and e-file them in just a moment. Mr. Lake, do you have any questions?
No, Your Honor.
All right, anything further with regard to this matter?
No, Your Honor.
Ron, I would just state that I'm not asking for this, cost, but I paid over $400 in photocopy fees costs for material that I sent to Ms. Boone along the way.
Hobson's like, I also paid $400. I'm not going to ask for it though. I don't want to push it, Judge. We all got our 15 grand. That's good. Judge orders $15,000 each. So what I'm going to do here is let's just take a look at these orders. A couple people sent me new documents in Boone. So let's look at them. Order on amended motion for attorney's fees. The Florida legislature and the JAC have set a flat rate of $15,000 or an hourly rate of $100 per hour for representation of an indigent defendant. And the court has approved $15,000 for fees to Frank Bankowitz. So that's his order. Let's take a look at the next one here. Next one is, and by the way, the reason all these look different is because each lawyer submits the order for their fees and the court signs off on it. Cause coming before the court for representation of Sarah Boone, indigent person in the above style case. Court having reviewed billing and response submitted to JAC finds the fees as set forth below are appropriate and reasonable, and the usual and extraordinary time and effort took place. And that's where I kind of am like, I guess we work crazy on cases, right? I will admit that our firm probably overworks a lot of cases. So I would not have said this one was with 2 bankers boxes was like extraordinary and unusual personally. But anyways, the judge awarded the amount of $15,000 in attorney's fees, $1,800 in cost to Patricia Cashman. Okay. And the last attorney's fees is from Hobson. Came before the court. Fees as set forth below are appropriate. Fees are incurred as a result of representation in this case, which is unusual and extraordinary, and therefore merits compensation exceeding the statutory limit. 200% of the flat fee for all the attorneys in this case would be confiscatory. Therefore, counsel is to be paid the rate of $15,000 for a case and issue of 200 hours of billable work. He actually put in the most hours, even though it was 8 months. Bankowitz worked almost twice as long, but only 175 hours. But Bankowitz got the $15,000 flat. Cashman, $15,000 flat. Hobson, $15,000 based on the hours. Because of the length of representation in this case, multiple attorneys appointed, the volume of discovery, the witnesses, depositions that had to be taken and reviewed, complexity of the issues, counsel is seeking a flat fee. The case involved voluminous pages of discovery, numerous photographs, numerous videos, numerous hours of recorded statements from the defendant and several witnesses, hours of jail visits with the defendant, numerous videos of the alleged criminal episode, review of expert witness material, tremendous number of letters from the defendant, reviewed and research of issues, numerous conferences with the investigator and expert witnesses. Therefore, Hobson gets his $15,000. It's kind of funny when I read through all this stuff and I'm like, I wonder what our playlist looks like. How many hours do we have into Sarah Boone, right? It's interesting to think about. Okay, I'm going to answer a couple questions here, and then we are going to get into the final or the newest witness that the state has brought to the table against Sarah Boone. Fletcher Boy said, Peter, aren't there motion hearings this week on this case? I believe the answer to that is yes. As they happen, we'll do them. You guys are always interested in Sarah Boone. Peter, if these lawyers actually work for that money, why not pay them? Why would they sign up for this program if they are not paid? They are paid. They sign up for a flat fee to handle the entirety of the case. They know this is something that could happen if they end up not finishing the case. AKA the cat lady said Sarah was at 71K before, added 45K. Now the taxpayers paid 116K before Owens experts. Woof is how you should have finished that. Can the judge's decision be appealed? My guess is JAC could appeal it. Unlikely. Rebecca said she was given 8 different lawyers. Again, how many chances does she get? Apparently, Mr. Owens thinks one more. In reality, the 8 lawyers is a misnomer. I think it was 4 or 5 that were legitimate that she blew. Peter, if Sarah's found guilty, can they require her to repay the public funds? So usually they don't. Usually it's like a nominal public defender fee of like $75 or something like that. She'll have court costs, investigative costs, things like that, but they're not going to come for $45,000 from her. So the $15,000 for some is emotional distress after dealing with Miss Boone. Sure feels that way, Joanne. It sure feels that way. Matthew, thank you for all the lives and videos, Peter. Perfect background noise to help me concentrate on expert witness work. Get it, Matthew. Get it. There's a couple off-topic things we'll talk about at the very end of the video, but first I want to bring up the last document we're going to look at together here, which is a notice of supplemental discovery, which generally speaking, I would be like, this is totally unfair for the state to do this at this point. But once we read it, you'll understand why. Comes now, the state of Florida by and through undersigned assistant state attorney, and hereby makes the following information available to the defense and states as follows. Abraham Moreno gave a statement to law enforcement in this case, which has been provided in discovery page 237 to 247. The undersigned assistant state attorney spoke with Mr. Moreno in advance of trial on September 23rd, which was yesterday. I believe the same day they filed this notice. Okay, so they're not wasting time. And the court cares about that. So they spoke on September 23rd. What did Mr. Moreno have to say? Why are they putting in a new witness? They have had all these years. What is this, a 2019 case, 2020 case? Yeah, 2020. They've had all these years. Why are they just adding this new witness now? Well, Mr. Moreno indicated to this assistant state attorney that the defendant was stating that what happened was an accident on the day of the killing. Mr. Moreno said the defendant stated that she was teaching him a lesson and things got out of hand and that she fell asleep. Mr. Moreno recalls the defendant making the statement prior to law enforcement arriving on scene. So that's not good for Sarah Boone for a couple reasons. Number one, the fact that she was saying it was an accident is going to be corroborative with other objective evidence such as body cam footage, interrogation footage. Multiple times she said this was not intentional. This was an accident. I didn't mean to do this, which doesn't really jive with the battered spouse syndrome, as we've already mentioned and as the court wanted to make clear. But once again, the court on the record said, Mr. Owens, this is the first time the defense is ever saying this was not an accident and that it was, in fact, self-defense. Therefore, intentionally doing something to him, George, to defend herself. So because that is a new aspect of the case, it makes things like this fair game. And usually I would complain if a prosecutor did something like this at the 9th hour. 11th hour, I think, is the hour that people complain about as being too late, not the 9th hour. I would usually complain about somebody doing this at the 11th hour or the 9th hour, or any hour past the first hour, but not under these circumstances where a new defense has been pled and they are allowed to respond and disprove. They actually have to disprove the battered spouse defense. They have to. But what else does this do that we've been keeping our eye on? It opens up the opportunity for the defense to yet make another motion to continue. Judge, we've got to depose Mr. Moreno. We've got to do some background on Mr. Moreno. This is a problem. So we'll see what happens. Jory said, why can she get 75 attorneys to the last hour? Jory, that is a great question when so many people can't. And you know, Mr. Owens said because everybody deserves a lawyer and he hopes everybody gets a lawyer. And that's true. And I agree with that. But the reality is there are a lot of people that don't have lawyers and can't get lawyers. And I really honestly believe the only reason it makes any sense in this case that all these people are coming forward now is twofold. Number one, the publicity, the media surrounding her case, maybe making a name for themselves, getting on the Know Your Lawyer channel and national TV and news stations. But also, I think a very legitimate reason is Mr. Owens. He has friends, he knows people, he has lawyers he trusts that trust him, that once he came on, other people were willing to come on as well. Alicia Joe said, bit behind, does she have a new judge? You have to admire how Miss Boone is going about this. Thank you for your insight. So no, this is just a judge to handle this portion of the case, not a new judge for the trial. All right, that's it on Boone, but a couple of other things going on in announcements. Reese's mom said, Peter, are you in the path of the hurricane? Azam said, Peter, is your area going to get hit by the hurricane? Well, as per usual, when things come up the west coast of Florida, I am in the path, and we will see what's happening. School got canceled already for Wednesday and Thursday. I will still be working as much as I can. As long as I have internet, I'm working. If there's content to be done, I will do it. We'll see if any of Sarah Boone's hearings get canceled or delayed because of the hurricane. And if they do, if that's going to delay the trial, all this stuff can be connected together like a domino effect. But you guys will be hearing from me. Follow me on Instagram and Twitter. I'll be providing updates there. The last couple years, we basically get hit by a hurricane every year. The last couple years, I have done one like on my back porch outside. We can see what the weather's like as the hurricane comes through, as long as it's not too bad, obviously. So keep an eye out for that. Rebecca said Ashley and I are the only 2 undefeated teams in fantasy. Yes, you are. And we've got our members only live coming up on Thursday, hopefully, weather permitting. And we're going to talk about new merch. You guys, the members, are going to design some merch, which will be fun. And we'll give a little fantasy football update. Azam, I am sorry, off topic. I don't remember if you have explained this yet. What is a prima facie argument? Thanks, Peter. 500K by the end of the year. I don't know. It's going to be tough to get to 500K by the end of the year. But make sure you guys subscribe if you haven't already, and make sure you like this video. Prima facie just means basic showing of a case. Like, have what you've explained enough? Is it a basic showing of a case? Basic proof of a case on its face? Does this seem like you have a case, or have explained it well enough, or proven your point well enough? All right. That's all we got. You guys are the best. Till next time, I'm out of here. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.